I want to ask you to imagine something. You're a graphic designer. You spend weeks creating a logo for a client. It's some of your best work. The client loves it. You get paid. 2 years later, that logo is everywhere. It's on billboards, on merchandise, on a website getting 1 million hits a month. You feel proud every single time you see it. And then it hits you. You do not own any of it, not a single pixel. You signed a contract with a work made for hire clause that transferred the copyright to the client the moment the file left your computer. You didn't just sell them a logo, you signed away every right you had to that design forever. Now, that's not a horror story I made up. It's a fact pattern I see in the real world regularly, and it happens to designers, photographers, musicians, illustrators, and writers every single day. Welcome to Spellbinding IP. I'm Julie King of King Patent Law. I'm a patent attorney, a business attorney, and a lifelong horror and rock music enthusiast, which means I think about things that can destroy your creative business the same way I think about what is lurking in a dark basement in a horror movie, with relish and with the firm intention of helping you avoid the monster entirely. Today, we're talking about IP strategy for creatives. And when I say creatives, I mean a wider group than you may think. Obviously, I mean graphic designers, photographers, illustrators, musicians, and artists. But I also mean writers, videographers, animators, architects, software developers, and crafters who sell their handmade work. And yes, I also mean content creators and influencers. If you're building an audience on Instagram, YouTube, or TikTok, you are creating original content every single day. Your photos, your videos, your editing style, your visual brand, your captions, all of that is intellectual property. And the contracts that brands send you for sponsored content are some of the most aggressively IP stripping documents in any industry. So this episode is absolutely for you, and I have a specific note for you a little later. Now, if you hire creatives, this episode is also for you because these rights flow both ways. Here's what we're covering today: the 4 IP tools every creative needs to understand, why copyright is both your greatest protection and your most common trap, how trademark protects your brand and not just your work, when patents matter for creatives, the work for hire nightmare and exactly how to avoid it, and a practical step-by-step for what to do first. Let's get to it. When we talk about intellectual property, we're talking about 4 main categories: copyright, trademark, patents, and trade secrets. Each one protects something different, and as a creative, your work often touches multiple categories at once. Let's start with copyright because it is the most immediately relevant to the work of creating and the one most people have at least heard of. Copyright protects original works of authorship fixed in a tangible medium of expression. We're talking about paintings, drawings, photographs, music compositions, sound recordings, written works like novels and lyrics and screenplays, software code, architectural designs, film and video. The category is broad. It even covers things like marketing copy, brochure design, social media templates, and digital art. All kinds of things that creatives generate on a regular basis, whether in the world of art or for business clients. Now, the first thing I get asked about copyright these days is whether something created with AI can be protected by copyright. Of course, the answer is it depends. Unless the human puts significant creative effort into the creation or modification of the AI output, copyright will not protect it. I go into much more detail about how AI affects copyright protection in a post and video I did a couple of years ago called "Can You Copyright or Trademark a Logo Designed with AI?" I will link that in the show notes, but next month I am doing a full episode on AI and IP covering copyright, trademark, patents, and the questions you are all asking. It's updated, thorough, and I am genuinely excited about it. Watch for it. Here's what most creatives know. Copyright is automatic. The moment you create an original work and fix it in tangible form, whether that means writing it down, recording it, or saving the file, you usually own the copyright. You don't have to register it. You don't have to put a copyright notice on it, although that remains a good practice. The protection exists from the moment of creation. Now, here's what many creators do not know. Automatic copyright and registered copyright are not the same thing at all in terms of what you can actually do with them in court or what you can do when submitting Digital Millennium Copyright Act or DMCA takedown requests in the US or equivalent takedown requests abroad. Sending a cease and desist letter without a registration certificate to back it up makes it harder to get the alleged infringer to stop. The first thing I do if a client receives a cease and desist letter, after confirming whether there is anything to actually worry about, is to demand proof of copyright ownership of the allegedly infringed material. No client of mine will pay anyone who can't prove that they are the rightful owner of the copyright. For online takedowns, you can submit a DMCA notice without registration, but if the alleged infringer files a counter notification, you have 2 weeks to initiate court action or the content goes back up, and you cannot file that court action without a registration in place. Which leads to, if someone infringes your copyright and your work is not registered with the U.S. Copyright Office, you can still sue, but only after you register. If you register at that point rather than before infringement occurs, your recoverable damages are limited to your actual losses, which are often difficult to prove and often modest. You cannot recover statutory damages, which under the Copyright Act can range from $750 to $30,000 per infringed work and up to $150,000 per work for willful infringement. You also cannot generally cover attorney fees. In practical terms, an unregistered copyright is a right without much power behind it. Someone can copy your work, post it without your permission, and even if you win a lawsuit, the award may not cover your legal fees. Litigation becomes economically irrational quickly, making it easier for the infringer to walk away having profited from your work. A registered copyright changes that calculation entirely. With registration before the infringement occurs or within 3 months of first publication, you have that access to statutory damages and attorney's fees if you win. Now a lawsuit is more economically viable. Now a cease and desist letter carries real weight. Now the infringer has something to lose. The great thing about copyright registration is that it is cheap and easy compared with trademark or patent registration. Online registration at the U.S. Copyright Office starts at about $65 for a single work. The Copyright Office website also has tutorials designed to make it easy for creatives to file on their own for most kinds of works. And if you do need legal help, most attorneys have reasonably low fees for assisting and will work with you on fees if you have a lot of works to register. For the protection it provides, copyright registration is one of the best investments in intellectual property law available to small businesses. Next, we have trademarks. Trademarks protect brand identifiers, words, names, symbols, logos, and other devices that identify the source of goods or services in commerce, like signature packaging. It protects your brand, not your creative work itself. If you're a freelance illustrator, copyright protects your illustrations. Trademark protects your business name, your logo as a brand identifier, and maybe a tagline you use in commerce. Two different things, two different protections. Most serious creative businesses need both. Your logo may be protectable under both copyright and trademark, but it depends on the level of creativity in the logo. Copyright will not protect simple arrangements of letters, numbers, symbols, or basic shapes. Trademarks can also be a little tricky. If you register a name in a specific color, arrangement, or font, you will only have protection for use in that particular style. Registering as plain text in black and white instead gives you protection using it in any style you want, and protecting text as part of a logo design leaves the text on its own unprotected. For a deeper discussion of this, check out my post called Name of the Game While Your Logo Trademark Isn't Enough to Protect Your Name. I cover these important distinctions in detail, and the link is in the show notes. For creatives who sell products, merchandise, prints, handmade goods, music, trademark is especially important because it prevents someone from putting your name or logo on their inferior products and confusing your customers. Now, creatives sometimes design their own logos or use logo creation apps or AI tools, and that can cause real problems with trademark registration. Canva's terms and conditions, for example, specifically state that you are not allowed to register any logo created through their logo creator for trademark protection. I go into much more detail about how AI and logo creation apps affect trademark protection in that Can You Copyright or Trademark a Logo Designed with AI episode and post. The link is in the show notes, and watch next month for a fully updated post on AI and IP. Now, what about patents? Most creatives do not immediately think about patents, but there are two types that are directly relevant to product-based creatives: the design patent and the utility patent. A design patent protects the ornamental, non-functional appearance of a product. If you design a uniquely shaped piece of jewelry, a distinctive piece of furniture, a product with a specific visual design, a design patent can protect that appearance and prevent competitors from copying it. Design patents are generally less expensive and faster to obtain than utility patents. Now, while a design patent protects how something looks, a utility patent protects how something works. Anything from an apparatus that helps an artist create something in a special way, to a new guitar effects pedal, a chemical formula for a kind of paint or resin, a method of creating something, and more. If you make products with distinctive visual designs, design patents are worth a conversation with a patent attorney. And if you've come up with something truly innovative, it may well be worth exploring a utility patent as well. Sometimes it makes sense to protect a design through both trade dress trademarks and design patents. For more on that topic, please check out my posts, Trade Dress Trademarks versus Design Patents, Doubling Product Design Protection via Design Patents and Trade Dress Trademarks, and Trademark Lawyer Tips, The Secret to Immortal Design Protection. Finally, we have trade secrets. For creatives, trade secrets might mean a proprietary process, a technique, a formula, or a method that gives you a competitive advantage, and you keep that confidential. Trade secret protection is available without any registration as long as you remember to take reasonable steps to maintain secrecy. We'll cover trade secrets in detail in a future episode, and you can check out my short called Trade Secret versus Patent. Which one should you choose? Now, I want to go deeper on copyright because there are two specific issues that affect creative businesses over and over and over again, often in unexpected and horrible ways. The first is work made for hire. The second is the difference between licensing and assigning your rights. Work made for hire is a legal doctrine that says in certain circumstances, the person who paid for the creation of the work, not the person who actually made it, is treated as the legal author and owner of the copyright. There are two scenarios where this applies. First, if you created the work as an employee within the scope of your employment. If you're a staff designer at a company and you design their marketing materials during work hours, those belong to your employer. Most employees do understand this, but the second scenario is where independent contractors and freelancers often get blindsided. Under the Copyright Act, there's a specific, limited list of categories in which a work created by an independent contractor can be considered a work made for hire, but only if there is a written agreement signed by both parties that specifically designates the work as such. Those categories are contributions to collective works, parts of motion pictures or other audiovisual works, translations, supplementary works, compilations, instructional texts, tests, answer material for tests, and atlases. For graphic designers, photographers, illustrators, and musicians working as freelancers, this category list matters enormously. If a client inserts a work made for hire clause in your contract, and if your work can arguably fit one of those categories, you may just have transferred your copyright. And even where the work does not technically qualify as work for hire under the statute, many client contracts include outright assignment language that accomplishes the same result. Assignment means you transfer ownership of the copyright permanently. You get paid once, the client owns the work forever. So how do you protect yourself? Read every contract before you sign it. If you see the words work made for hire, assignment, all rights, or all intellectual property rights, understand exactly what you're agreeing to. Know whether you want to negotiate a license instead. So an assignment is permanent. You transfer ownership of the copyright, done. The client can use the work however they want, in perpetuity, without paying you another cent. A license is permission to use the work under specified conditions, for a specific purpose, for a specific time period, for a specific territory. You retain ownership. The client gets the use they need, and if they want more, they come back to you. For an established creative, licensing rather than assigning can create a recurring revenue. The same illustration, licensed to different clients for specific purposes, multiple times over years. That is the IP asset model working in your favor. A full assignment should be priced significantly higher than a limited license. When a client says they need something for all uses forever, and a client who says they need for their website only, those are fundamentally different transactions. Price them accordingly and make sure you retain the right to use the work in your portfolio if you want to. I want to pause here and speak directly to content creators and influencers for a moment because the work for hire and assignment issue hits you especially hard. Brand deal contracts, the agreements brands send you for sponsored content and UCG, user generated content, almost universally contain sweeping IP assignment clauses. Read them carefully. When a brand asks for all rights to the content you create for them, they mean it. They are asking you to permanently assign the copyright to content you spent time, creativity, and equipment costs producing. That content can then be repurposed in ads, on their website, in their marketing, potentially for years with no additional payment to you. You should also be aware that the major platforms, Instagram, YouTube, TikTok, contain licensing provisions in their terms of service. By posting content, you are granting those platforms certain rights to use your content. That does not mean you give up ownership, but it is worth understanding what rights you are granting and to whom. Finally, music in your videos is a real and ongoing enforcement issue, possibly an enforcement nightmare. Using commercially released music without a license, even briefly, even as background, even something you love, can get your video demonetized, muted, taken down, or worse. Platforms have Content ID and similar systems that catch it. If music is part of your content, understand your licensing options. Royalty-free music libraries, sync licenses, or platforms with music licensing built in. Now, be careful when you're on the various platforms because if you're using a personal account that has access to far more music for business purposes, that can land you in a heap of trouble. And that's one reason my posts don't have much great music because I have to have a business account because I'm using it for business purposes. Sucks, but true. Your name, your handle, your visual brand aesthetic, and the distinctive look of your content may all be protectable as trademarks or trade dress. You are building intellectual property assets every time you post. Treat them that way. Now let's look at a real-world example of how copyright disputes play out at a significant scale. In 2009, artist Shepard Fairey was sued by the Associated Press. Fairey had created the iconic Hope poster for Barack Obama's 2008 presidential campaign, basing it on a photograph taken by AP photographer Manny Garcia. Fairey had used the photograph without obtaining a license. The case ultimately settled in 2011 with undisclosed financial terms and a revenue-sharing agreement. Now, I'm not going to litigate the fair use questions in the Fairey case here because the analysis is genuinely complex and the settlement means we never got a final judicial ruling on the merits. What I will say is this. The case illustrates that even when you are transforming a work into something new and artistically significant, using photographic references or other source material without understanding and addressing the copyright implications can result in expensive litigation. Know what rights you're using and whether you have the authority to use them. Let me give you a concrete sequence of steps that will help you protect your creative work. Step 1, identify what you create. Make a list. What are the copyrightable works you produce? What are the brand identifiers associated with your business? Start with an inventory so you know what you're protecting. For content creators and influencers, that list includes your content library, your handle, your visual brand, and any signature phrases or formats you have made your own. Step 2, register your most important works. For works that represent significant time investment, have commercial value, or are especially vulnerable to copying, register with the U.S. Copyright Office at copyright.gov. If you produce a high volume of works, ask a copyright attorney about group registration options, which allow you to register multiple works for a single fee. Step 3, file a federal trademark application for your brand identifiers. If you've been using your business name and logo in commerce, you likely have common law trademark rights, but those rights are limited to your geographic area of actual use. A federal trademark registration provides nationwide rights, a legal presumption of ownership, and the right to use the registered trademark symbol. Before you file, get a comprehensive trademark search, not just a USPTO database check. Common law marks matter and can block your application. Step 4, get your contracts right. Every client engagement should be governed by a written contract. Every single one. The contract should specify what you're creating, what rights the client receives, whether it's a license or an assignment, the scope and duration of any license, how payment works, and who owns work that is not delivered or paid for. You all know that happens. Make sure you retain the right to use the work in your portfolio if you want to. If you're regularly using a form contract, have an attorney review it. Generic templates from the internet are not written for your specific situation or your state's laws. Step 5, document your creative process. Keep dated records of your work, drafts, sketches, version histories, project files, emails. In a copyright dispute, your ability to demonstrate independent creation, when you started, how the work developed, is valuable evidence. Cloud storage with automatic timestamping is your friend here. Step 6, know when to call an attorney. For copyright registration of straightforward works, you can generally handle this yourself. Now for trademark, work with an attorney. Trademark law is more complex. The categories matter, the search matters, and a rejected application costs money and time. For contract review, anytime you see language about work for hire, assignment, or IP ownership that you do not fully understand, get a review before you sign. The cost of a contract review is almost always far less than what you unknowingly give away without it. Here are your key takeaways from today. 1. Copyright is automatic at creation, but registration gives it the power. Register your most important works before publication or within 3 months of publication. 2. Work made for hire and assignment clauses can strip you of rights to your own creations. Read your contracts before you sign, every time. 3. A license is not an assignment. You can license your work and retain ownership. Understand the difference and price accordingly. 4. Trademark protects your brand. Copyright protects your work. Most serious creative businesses need both. 5. Design patents can protect the distinctive appearance of products, and utility patents can protect innovative processes, tools, or formulas. If you create something genuinely new, it is worth a conversation with a patent attorney. 6. If you're a content creator or influencer, you are building IP assets every single day. Know what you're signing in brand deals. Understand your platform terms. Protect your brand identifiers. It all boils down to what The Clash said, even though they weren't talking about intellectual property. Know your rights. There's so much more than I could fit in an episode of a reasonable length. I've put many links to useful related episodes in the show notes for this episode, and I encourage you to browse or search prior episodes for related topics. If you look closely enough, you may find some with me in costume for spooky season. And now it's FAQ time. Question: I posted my artwork on Instagram. Does that count as publishing it? Answer: generally, yes. Publication in copyright law means making copies of a work available to the public. Posting on social media is typically considered publication. This matters because if your work is infringed after publication, the timing of your registration determines whether you can recover statutory damages and attorney's fees. Question: can I copyright my art style? Answer: no. Copyright protects specific expression, the actual painting, photograph, or illustration, not the style, technique, or ideas behind it. Someone can paint in a similar or identical style without infringing your copyright, as long as they don't directly copy specific protected works. This is a painful reality for many artists, but it is the law. Question: I created a logo for a client on a handshake deal. Who owns it? Answer: if there is no written agreement, the general default rule is that the independent contractor who created the work owns the copyright. The client may have an implied license to use the work for the purpose it was commissioned, but the ownership stays with the creator absent a written assignment. Now, this cuts both ways. Creatives often own more than they think, and clients often own less. Question: can I use AI to create my logo and trademark it? Answer: it depends on what tool you used, what its terms say, and how much human creative effort went into the final design. Some platforms like Canva explicitly prohibit trademark registration of logos created through their tools. For a full breakdown of how AI affects copyright and trademark registration, check out my post and video, Can You Copyright or Trademark a Logo Designed with AI? See the link in the show notes, and stay tuned because I am doing a full updated AI and AP episode next month. That's all for now. Thanks for watching or listening. If you're ready to protect your creative work and the business you've built around it, book a consultation at kingpatentlaw.com. Avoid the legal horrors and keep rocking your IP. Finally, a reminder that this information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney.